Aye. Okay, we are back in Senate institutions and we are reviewing the age appropriate design code bill. And we have the Attorney General, Charity Clark, here to let us know how she considers the bill and perhaps answer some questions.
Sure.
Thank you so much.
Thanks for having me. We are always excited to see work in space. And one of the reasons why is because we investigated Meta as well as TikTok regarding their harms against teens, especially, and the algorithm, all the rest of it. And unfortunately, what we learned was not good. And we ended up suing Meta in, I think, October of 2023 and TikTok in October of 2024. So what we learned was disturbing. And unfortunately, the TikTok complaint is not fully, we had to submit it, file it redacted, and we're still arguing about whether we can unredact it. And there's some compelling data in there about Vermont teens. So when that eventually, hopefully, will be unredacted, you'll get to see that. But we have that information. It is disturbing, and so we're glad to see the Senate taking up this bill. I know that this is not the first go round with this bill. We were involved with providing feedback during the first go round to try to make it a meaningful bill that wasn't duplicating something that was already being done. The reason why we could sue Meta and TikTok is because of the Consumer Protection Act. Consumer Protection Act is very broad and flexible. It prohibits unfair and deceptive acts and practices in commerce. It's very old. I mean, not very old, it's older than I am. It's not like 200 years old, but it's over 50 years old. And it's been around a long time. We've used it in some very important, and I would go so far as say famous cases, the most famous being the tobacco case. That was a consumer protection case. Basic idea is if you are misrepresenting in the marketplace, if you're not being honest with consumers, it's actionable because it hurts consumers and hurts the marketplace. I always point that out. When you're hurting consumers and there's a sense of distrust, the marketplace is not a healthy place. And so that's one of the reasons why there is a Consumer Protection Act. Every state, we're not unique at all, and they're very much the same. So we have that lawsuit, but it's like I say, it's not specific. It talks about unfair and deceptive acts and practices. This is specific. It provides a lot more information and detail about what that might look like. So, and it clearly is informed by the reality of the algorithms and social media in particular. So we are really happy to see this. And I won't go into some of the details. We can always provide some feedback on some of the details to Ledge Council or whoever as you go. But I understand that you were particularly interested in the private right of action. So I prepared to just talk a little bit about the private right of action. The private right of action is something you see throughout the law. So I'll give you a classic example. If someone hits you with their car, should the Attorney General be the person who sues that person? That sounds very inefficient, like a burden on the Attorney General, i.e. the taxpayer. No, you yourself have a right to sue. So that's a private right of action. It's something that's given in statute through the Consumer Protection Act. And I flagged it so that I could tell it to you. But it's that any consumer who's acting in the marketplace and sustains damages or injury as a result of any false or fraudulent representation or practice, I'm skipping that lots of may sue for appropriate equitable relief, meaning you're for your damages, for the harm that you suffered specifically, and may sue and recover from the seller, solicitor, et cetera, et cetera. So that's the basic thing. Now, this is different language from the Attorney General's ability to sue. So the private right of action is about actual damages. It's the harm, the injury that you suffered. Classic example, I bought a blender. It cost me $100. It never worked. They wouldn't take it back. I could sue them for $100. I got my $100 back. That's the actual damages. The Attorney General has a different power. The Attorney General can sue for up to $10,000 per violation, which can be for some, for example, the tobacco industry, a ton of money. The tobacco settlement was, I mean, it's unprecedented in history. And even little tiny Vermont every year gets like $25 million a year as a result of that settlement. So the Attorney General's power is very large. The amount of money at stake could be very large. The private right of action for a consumer under the Consumer Protection Act is about actual damages. So keep that in mind.
Matt, is it okay if we ask questions?
Of course, yeah.
So in that, excuse me, and, because I'm not a lawyer like you two, or you three. It said, deceptive acts. Would they consider a deceptive act not, disclosing something?
Omissions
Okay.
count. Yep,
Omissions count, okay, so.
that's right.
All right.
So an example there, so now I'm putting my professor hat on, which is so fun. So an example there would be the, well, even the tobacco company, but I was thinking the fossil fuel company. You know, we sued the fossil fuel companies because they didn't tell us the information they had about what their products were doing to the environment. That deprived consumers of a choice to pick something else or to make an educated choice about the purchase they were making. So omission counts. Yeah, that's well established. Okay, so I'm telling you about the private right of action. That is the general gist of it. I think it's not controversial. It is extremely understandable that if you are a business in the marketplace, you don't want to get sued and you don't want it to make it easy for people to get sued. We can all acknowledge that. That doesn't mean that we shouldn't have a private right of action. You know, that's not necessarily what I would recommend. And I think Vermonters really want to have that right. Moreover, and this is critical, the Attorney General does not represent individuals. I represent the state. When the state is harmed, that's when I get involved. And I mean, criminal cases the same. It's never, you know, victim versus so-and-so. It's state of Vermont versus so-and-so. And so I can't represent all individuals. I'm actually literally not even permitted to represent individuals. I can only represent the state. And so the private right of action acknowledges that an individual person has the right to sue if they are harmed. And I mean, I think about myself, if I were harmed, I would want the ability to sue. It's not something that I would want someone to be doing for me. And also it's important to keep in mind, the more work that the Attorney General has to do is the more work, the more money taxpayers have to pay, rather than shifting the burden to the private sector, to the individuals who did the harm. Now you're asking the taxpayers to have more lawyers to do the work. So that's something that's critical to kind of point out as well. I should also note that it is common for laws that protect consumers to have a private right of action. That's kind of the norm. In addition to the Consumer Protection Act, the Fair Credit Reporting Act, Vermont has our own version of that. The Fair and Accurate Credit Transactions Act and the Cable Communications Policy are all things that have a private right of action. That's the norm, that's the standard. What other things that I want to talk to you about? Well, I could talk to you all day about Meta and TikTok and the danger, but what can be helpful?
Well, how about this industry? They're not apparent. We don't know what's behind, you know, as customers, and especially as children. Children aren't aware of the algorithm, the infinite scroll, and they can't turn that off. Even just privacy controls are complicated and they change, and it's probably intentional that the way that you say that you want privacy changes. I've seen that happen just on sites that I use. So just the relative power of the companies versus children.
Yeah. Well, I mean, the thing to keep in mind, I mean, obviously the bill addresses this, but this is by design. These products are designed to be addictive, as we learned with tobacco, or Diet Coke, whatever, you know, the addictive thing is. Even coffee, these are addictive. Unlike coffee, the social media is very harmful, and we can show that, you know, evidence. We have that evidence. So the addictive nature is extremely problematic, especially for teenage girls, statistically. Part of the kind of challenge is, I mean, we are consumers because we are trading our data. And that is why you hear me talk about data a lot. I'm obsessed with our data privacy. I mean, I think a lot of people are getting a window into why that is with recent events on the federal level, and they're kind of learning about why data privacy is important. But the truth is, what we're buying social media with is our data. It's not money, it's our data. They use our data to sell advertisements to get us to buy things. And so there's a whole process there. And all of that we don't have access to. You're right. We're just the product being sold. And social media nowadays, I think it's a part of like everyone is on social media. That's kind of the norm. And so for young people to want to be on social media, that is understandable, but their brains are still developing. So to the extent that anyone here is thinking, I spend too much time on social media, imagine being 13. Your brain is not developed, and the addictive nature, the compulsive nature, that's all by design. All of these products are designed to elicit that kind of behavior, which is incredibly concerning and damaging to the health of youth. And they use all these tricks to make sure that happens. And the truth is, as an example, a person who has an eating disorder might be continuing to look at videos on Instagram that kind of glamorize eating disorders. And they're going to want to keep looking at it because so the algorithm is just going to keep feeding them. It doesn't judge. It's just going to keep feeding them the literal feed. I think that's what it's called. The feed that they are looking at, because it wants to get as many eyeballs on as many things as possible and that's also push notifications. Don't miss out. Better, get back to the apps because you got a notification. Same thing with ephemeral content, like an Instagram story, it disappears after 24 hours. So if you don't check your Instagram every 24 hours, you might miss some content and miss some of whatever your friends are doing or your frenemies are doing. So it's very problematic. And that's why we sued, and that's why this issue has been so important to us.
Great, thank you. And Facebook is doing that ephemeral stuff now too.
Yes,
It just goes away in 12
they're
hours.
finding out what works. I mean, it's interesting when the tobacco formula a key part of the tobacco formula was to get people hooked early so that they would be loyal to your brand. And I think that's something else that people are learning is like, why are you creating content that's obviously not designed for people who even can buy things because they're too young? What would the point be? It's like, oh, because you want to get them to be a loyal customer now so that you'll get them for life, and then you'll continue to be able to make money off of them by selling ads or however you're making money in the future. Yeah.
Thank you. And then could you speak on the likelihood of us of the legislation being overturned by courts, because that's a concern.
Yeah, one thing that we are always mindful of is when the legislature passes a law that might bring a lawsuit against the state, we defend the lawsuit. So I don't tend to say a lot about that issue, and you have your own lawyers who can weigh in on that. I will say this is fairly novel, but there have been other states who've acted in this space, and I think they have been sued. So it's nice to be able to monitor how those cases are going and see, okay, well, what would that look like for us here in Vermont, and what maybe we can make a better bill if there's problems with a bill once you learn more about how those lawsuits are going. So that's always instructive. And in terms of our own lawsuit, we survived a motion to dismiss, which has been appealed. That's in the Meta case. And I think I can't remember the TikTok. Okay. Anyway, we're in a similar posture there as well. So the lawsuit isn't necessarily going to be resolved anytime soon. So while I'm saying it's nice to have the example of other states that are acting in this space and have already kind of ventured forward with a bill and have been sued, waiting is also not super appealing, because every year that passes, there's more kids who are spending an unbelievable amount of time watching their phones every day instead of sleeping
And getting their data
and getting
sold.
and getting their data sold.
Yeah.
The other thing that I always mention, and not everybody mentions this, but for some reason I'm like a thrifty Yankee that bugs me. Why is it that I'm giving this product and you're using my data and I'm not getting a cut of it? I feel like I want some of that money. Like I guess I'm getting social media in exchange, but I'm like, I'm not sure that's a fair trade. I think I want more. So
All right. That's understandable. So questions from anyone?
If I could recommend, I know there are a lot of teachers, parents, and children who can weigh in on this, and I think that they would make really compelling witnesses, and we can try to put you in touch with some. I'm saying that in part because when I'm on a 2-year cycle, so I ran it as well last year, and everywhere I went, people gave me feedback about our lawsuits against TikTok and Meta, and I was kind of taken aback, to be honest, because I was expecting, housing, public safety, which I always had heard about, but I was like, wow, people are a lot. I was surprised, even me, because I'm so into this with our lawsuit, but even I was surprised by how passionate people felt about it. And even we had in my kids' school, we had like a fire alarm that required everybody to leave for the day, and kids were not permitted to go back and get their phones and their backpacks. And I heard from people who were there that it was like actually disturbing to watch kids who were doing fine when they learned that they weren't going to be able to get their phone for a day. They like melted down, and how just realized, because they're addicted to their phones, and it's troubling.
So there is, oh, I'm sorry.
No, go ahead.
So given that, and there is legislation that bill to take phones away in school. How is that going to affect the kids? I mean, I don't have kids. What are your thoughts?
Well, I mean, I think we can learn that because there are districts where that's already happening.
Yeah.
So that's helpful data. For us, I can't imagine being a teacher and having to compete with the algorithms that have been designed by like psychologists to keep children looking at them. It is really troubling. I've never felt like more old than the gap of, being free from that and feeling like I don't feel attached to my phone in the same way. And it is when you see young people like compulsively on their phones, and it is really troubling. Like, just put it down, and they can't, because they're literally addicted. And it is really troubling. So I definitely have supported that, and I think there's a good way of doing it that just is going to make it easier for teachers and for students to learn and be free of the product that they're addicted to.
Thank you.
Okay.
Anything else? Are we good?
Yep.
Thank you very much.
As you know further, we're happy to come back and answer any questions you have.
Sure, we'll probably
Thank-
finish next week.
Okay,
so,
and thank you for your
okay.
work on this.
Thank you.
Thank you.
Thank you.
And thank you for your work. Good luck on those lawsuits.
Thank you. We are kept busy.
Stephen.
She did. I knew she would.
No.
Bailey stayed. Yeah. She said she would. All right. So Bailey, thank you very much for your patience. Appreciate that.
No problem. Happy to be here.
All right. So would you like to just start?
Yeah, sure. I have a couple pages of testimony, and then I can take questions on anything that sparks interest. So my name is Bailey Sanchez, and I'm Deputy Director for U.S. Legislation at the Future of Privacy Forum, or FPF. FPF is a
Excuse me one sec, just hold on.
Are we gonna start posting some of these? We're getting a lot of the folks are bringing testimony, but we're gonna put them online, so
All of this is online.
okay, it's not on our webpage.
Yeah, I get them after a lot of the time, so the ones that I.
Oh, you mean the written testimony? Yeah, so any written testimony that we have, that you have received, is it on the
Yes.
website? Okay.
Okay,
We've asked for it for everybody, but we don't get it from everybody. And some of them say we'll get it to you.
Yeah, in this case, I think it's a me issue, not a process issue, so I can get that to you right after this.
All right, thank you. And see, we actually read stuff too, so it's worth it, worth your time. Okay,
Okay.
please proceed. Thank you.
Sure. FPF is a consumer privacy nonprofit focused on advancing principled data practices in support of emerging technology. In my role, I closely monitor new legislative frameworks that impact youth privacy and online safety. I'm here neither to support nor oppose the Vermont AADC, but to share my expertise on data privacy and online safety as the committee considers this bill. I would like to make 3 points today. First, Vermont is also considering a broad consumer data privacy bill, S71. Baseline consumer privacy laws provide important protections to all consumers, including children and teens, and this would be an essential step for addressing many risks to young people online and as they age into adulthood. Second, much of the testimony this committee has received thus far has addressed the perceived harms of social media platforms. While some of the provisions of Vermont AADC specifically address social media companies, the bill broadly applies to all online services reasonably likely to be accessed by individuals under 18, essentially every public-facing company. Understanding the full scope of services governed by S69 and how its passage would impact them is critical as the committee considers this proposal. Finally, as part of my work analyzing new legislative frameworks, I've also closely monitored legal challenges to recently passed online safety legislation that have led to injunctions against laws across the nation. Two common themes from this litigation are constitutional concerns with regulating content and with requiring age verification. This Vermont AEDC has taken new steps that seek to avoid regulating access to lawful content. However, it is unclear if the bill requires age assurance, and that may raise constitutional questions. So first, speaking about comprehensive privacy legislation, enacting a strong baseline consumer privacy law can address many, though not all, concerns with young people's online experiences. While the United States lacks a national data privacy regime that sets baseline rules for collecting, using, and sharing personal information, 19 states have passed comprehensive consumer privacy laws. These laws apply broadly to all consumers, but notably young people benefit from these frameworks and in many states even receive extra protections for their data. Common elements of a consumer privacy law include consumer rights, such as the ability to access, correct, and delete personal data, and business obligations, such as transparency requirements about what data is collected and how it is used, as well as accountability mechanisms such as risk assessments. Additionally, these frameworks often classify minors' data as sensitive, prohibit the sale of sensitive data, and place restrictions on the processing of sensitive data without the informed consent of individuals. In the case of Vermont S71, this framework would create additional protections specifically for minors. S71 requires controllers to use reasonable care to avoid any heightened risk of harm to minors caused by processing personal data while providing an online service, product, or feature. And it places a flat prohibition on selling a minor's data or processing data for targeted advertising. I understand that S71 is with a different Senate committee, but we encourage you to consider what harms to children and teens online may be alleviated by a baseline privacy law that protects all Vermont residents. Separately, I want to caution taking care to avoid any possibility for conflicting requirements, such as multiple duties of care to protect children, requiring multiple visible signals to minors when their geolocation data is being collected, or establishing conflicting standards for what data may be collected and how it may be used. Second, on the scope of the Vermont Age-Appropriate Design Code. So the Vermont AADC applies to entities that conduct business in Vermont and whose online products, services, or features are reasonably likely to be accessed by individuals under 18. The bill lays out several factors for assessing reasonably likely to be accessed, such as services that are directed to children or internal company research showing that at least 2% of the audience includes minors ages 2 to 17. Again, much of the testimony so far has focused on social media, but critically, this bill applies to many more services beyond social media. Consider older teens and how their interests are likely to overlap with those of young adults. A website that's likely to be accessed by a 17-year-old would very likely include most of the internet. The bill includes a vital exemption for entities whose primary purpose is journalism, but otherwise it broadly includes many websites or apps that you or I are likely to browse. I encourage this committee to keep the full range of services and scope of the bill in mind as you further consider the proposal. The requirements under this bill are likely to impact industries ranging from streaming services, video games, shopping sites, and health and fitness apps. Finally, on constitutional questions with online safety legislation, over the last few years, several other states have considered legislation to create protections for young people online. However, several past bills have been subject to constitutional challenges, including the California Age Appropriate Design Code, which is currently partially enjoined, and the Maryland Age Appropriate Design Code, two laws from which this bill draws inspiration. Although litigation is ongoing in several states, including where courts have enjoined these laws, key insights can be gleaned from various court opinions so far. In Net Choice versus Bonta, the Ninth Circuit affirmed a preliminary injunction preventing the risk assessments in the California Age Appropriate Design Code from going into effect. The risk assessment there would have required companies to assess whether the product's design could harm children, including by exposing children to harmful or potentially harmful content, contacts, and conduct. Because these risk assessments required companies to opine on content-related harms and what content or proxies for content may be harmful to children, the court held that this section was likely to fail strict scrutiny. To be clear, though, not all risk assessments are unconstitutional, and risk assessments can be an important tool for privacy law. But in the case of California specifically, they were not focused on data use, but rather content. S69 takes the unusual step of not requiring companies to conduct any risk assessment. And we also note that S69 clearly states that the content of the media viewed by a minor shall not establish emotional distress or compulsive use in the minimum duty of care owed to minors. However, another key insight from the online safety litigation landscape is generally that courts closely scrutinize frameworks requiring age verification. Notably, the Supreme Court heard oral arguments requiring age verification for an adult content law, and much of the oral argument was focused on the state of the technology and whether it has sufficiently advanced since this topic was last heard at the Supreme Court over 20 years ago. While it's possible courts may be open to age verification requirements targeted to specific types of online companies, such as adult content, they have appeared more skeptical of requirements that would broadly require all online services to determine or estimate the age of users. Requirements for age verification often aim to either restrict children from a service or determine who is a child so the appropriate safeguards can be given to them. While the intended goal is to protect children, these requirements generally impact all users and may require all users to go through an age verification process. It is actually unclear to me whether the Vermont Age Appropriate Design Code affirmatively requires age verification. The bill defines a covered minor as one that the business actually knows is a minor or labels as a minor in line with methods adopted by the Attorney General. I know there was some discussion on this in testimony. Either it's unclear to me if that or means you have to pick one or the other, or it's just optional. And then, of course, the bill further provides several considerations for the Attorney General in promulgating rules regarding commercially reasonable methods for age verification. Clarifying the bill's intent for the level of age assurance that businesses should conduct would be helpful. We appreciate that Vermont has taken care to create safeguards, such as implementing a review process for appealing age designations and prohibitions on using data collected for age verification for other purposes. Still, given the constitutional concerns surrounding age verification and the still evolving state of the technology, we urge both specificity and caution on this topic. Thank you for the invitation to provide testimony, and I can answer any questions you may have.
Great, well, thank you. Thanks again for your patience through this. Do we have questions? So you brought up some really good points. So will you you will provide written testimony?
Yes, I can send
Good.
it right after this.
Good. Okay, no questions?
No, thank you.
All right, thank you very much.
Thank you.
All right. So that is our agenda for today. Tomorrow we'll start at 1 also because we don't have the floor. And we do have a full slate of witnesses. We may get some more too. We've had a couple folks. Is the person from the banking organization?
They're not available to them.
They're not. Okay, we'll do that. So I expect we'll, next week, we'll take this up again on Tuesday. I think we might be able to do a markup on Wednesday. Oh, you folks need to let me know if you have witnesses, by tomorrow, right? Let me know. Actually, if you have it today, that would be really helpful. If you have witnesses that you want to hear from. Okay?
Okay.
We just need them so that they have time to prepare the plan. All right,
Good.
Good.
so I think we are good. So